Good girl. Howdy, and welcome to the show. Cooper's Code focuses on legal issues and helps people, practitioners, do the best they possibly can to help their clients. Today we're going to talk a little bit about how a contingent fee firm handles the challenges and risks of financing cases with the recognition that a lot of our cases do not resolve quickly and they don't resolve certainly. An episode like this is appropriate for anyone who works in the contingent fee world. Whether you're running a firm and have been doing so successfully for a long time, it gives you some ideas on how you might want to rethink your cash flow and how you might want to rethink how you handle things. If you're considering opening a firm, these are the types of things that you want to consider because you have to have the recognition that you may need something to cover your overhead for almost 3 years. And if you're working at a contingent fee firm, these are things that are helpful to know. So when you see the owners or partners are looking stressed, or there are issues with someone saying, well, you know, we're deep into the line of credit, you understand exactly what that means. Because some firms are very transparent about what it's like to run the firm, and other firms are less transparent, and it really helps to understand what's going on beneath if you're going to do the best job for your cases and your clients. So if you were to say to somebody, hey, I'm going to run a business, and I'm going to run a business where I have either maybe 10 receivables, 15 receivables in a year, or I have 0 receivables. I might make a lot of money on them. I might make 0 money on them. And I never know when these receivables are going to come in. Somebody's going to probably look at you and say, that sounds like a terrible business. Why would you ever get involved in that? The answer is contingent fee work has the potential for significant upside. The upside is that cases on contingent fee sometimes can generate a tremendous amount of revenue. The downside is you need to have some sort of funding planning to make sure that you can weather the storms. So the most common way when people first start out that people start handling cases is they will oftentimes use their own personal funding, combination of credit cards, and a combination of a lot of co-counsel work. What does that mean? How does that look? Co-counsel work allows you to spread risk. So if you have some good cases coming in, but say you don't have a lot of money to be able to hire the experts, you can work with another firm and you can give them some of the fee and then have them carry some of the expert costs. And as you slowly do that, that allows you to build up your bankroll. Borrowing from family members, and I've known a lot of lawyers who have started their first few cases on credit cards. These are ways that you can go ahead and start building a bankroll. There are various analogies that one can use. A common one is World Series of Poker analogies. For those who aren't familiar with the World Series of Poker, you either have to win a bunch of tournaments in order to get in, or you have to buy your way in. And the people who are very experienced and have big bankrolls, they can just go ahead and buy their way in. But for a lot of people, the way they get in is they'll get that buy-in from somebody else, and then they'll share half the proceeds from it. So there are a variety of ways that you need to structure it to make sure that you can weather the storm. That initial going out on your own can be very scary, and it's something that you shouldn't be doing in a reactive fashion, meaning you shouldn't just decide one day, gosh, I'm done being a defense lawyer, I'm going to become a plaintiff's lawyer, or I'm done at my plaintiff's firm, I'm pissed off about whatever, and I'm going to go start out my own shop. You want to put a lot of thought into how do I get through 18 months to 3 years of being able to run the firm, and where's that cash going to come from? And not just for payroll and overhead, but also expert costs and all the things that you need. So the most common tool that a plaintiff's lawyer uses to get this going, that goes beyond loans, co-counsel, and credit cards, is working with what's known as a line of credit. So a line of credit comes from a bank. Most of the types of banking that plaintiff's lawyers do are what's known as relationship banking. So what do I mean by that? Banks typically are looking to collateralize whatever loan they make. So let's think about buying a house. When you buy a house, you demonstrate that you've got good credit. you put a down payment on the home, and you get a mortgage from someone who is willing to give you a mortgage. With that, the bank has collateral. What's the collateral? Well, if you default on the mortgage, they are the ones who actually own the home, and they're the ones who can sell the home, and they'll get their money back. They have some certainty that they'll be okay. Contingent fee cases really have very little in the way of collateral, meaning it's not something the bank can take all your cases and then turn into value. They're not lawyers. They're not going to want to try and find other lawyers to take over your cases. So what they're looking at is, who is this person? Are they trustworthy? Do they have a good history? And if we need to try to get our money back, how are we going to get it back? The most common way that they do that is they want to look at liquidity. So how much money do you as a lawyer or partners in a law firm have, so that if you default on the line, they can go after what you have. So oftentimes that's equity in a home, it's retirement plans, it's cash on hand. Now, the part of the challenge here is if you had the cash, you wouldn't need the line. It's somewhat of a delicate dance, and the way that delicate dance is done is you usually start with a very small line at the very beginning, and you build up a relationship with the banker, and you demonstrate your trustworthiness in being able to deliver on your results. How do you do that? You want to underpromise, overdeliver. And what that means, anytime a banker is willing to consider loaning to you, they're going to want to see your case list. They're going to want to see what cases do you have, how have you valued them. So let's say you've got 20 cases, and each of those cases you're going to go through and say, well, I think that this one's worth 100,000. I think this one's worth 250. I think this one's worth 500. You're going to value, when is that case likely to come in? And this is the underpromise, overperform. When we're valuing cases, we want to make sure that we value that case for far less than we actually think we're going to get on the case. And you want to overestimate how long it's going to take to get that case done. Now, the challenge in cases, particularly big cases in litigation, is you can get a trial continuance, you can get a new defendant. Sometimes there can be an appellate issue where you really aren't sure how long it's going to take. You try to be conservative in estimating things. And as you do this, one of the things you're going to find time and time again is one tends to be pretty good at underestimating the value of the case. So let's say you value a case at 100,000. Oftentimes you'll find that that case comes in at 150 or 200. People tend to be pretty good on the conservative side of that. Where people tend to have more challenges is the time a case is going to take. And we always try to be conservative on that approach, and yet we still find that sometimes it takes longer than we think it's going to take. And it's not just how much is going to come in on the case, it's what is the actual fee on that case after you've subtracted out any referral fees, what have you that might be in there. We started with an Excel spreadsheet called the active case list. It's gotten more complicated since then, and it allows us to project in real time where we think our cases are going to come in. Because we have had a history of doing exactly what I've said, underpromising, overperforming, our bankers know that we, over the last however many years, while we have on occasion had a loss, meaning we've had a case that's gone sideways and we've had to write it off, on the whole, we have delivered far more on each case than we've told them we were going to. And they've been able to say to their underwriters, these people are reliable. So you want to establish a long-term relationship with a banker. You take out that smaller line at the beginning. Oftentimes that smaller line is $100,000, $200,000 line. And then you just demonstrate to your banker that, hey, I can do this. I'm a trustworthy investment. The banks that you're going to look at are not typically your Chases or your Citibanks. They're usually a regional bank. And they're usually some, like a mid-sized bank. And the best way to find one is to talk to another plaintiff's lawyer and say, hey, who are you using to bank? A lot of bankers who've never done this kind of work before, they're going to be scared off by it. So talking to some plaintiff's lawyers, finding out who they use for their lines of credit is a great way to figure out who you should be working with as far as that's concerned. As you get bigger and you get more successful in terms of having a bankroll, you will figure out how much it costs to run your operation. Let's say it's $100,000 a month for employees, rent, etc. And then you build in a certain amount for expert costs and other things. You can then use laddered CDs and have that money invested so that every month you've got a new CD popping out and dropping out $100,000, $125,000, and that then keeps your firm running. The non-line of credit approach requires one to build a bigger bankroll, but the upside is you don't end up having to pay interest on taking the money out. There's some other good things to think about with lines of credit. A bank is usually going to want a period every year where the line gets rested. What does that mean? If you have a $2 million line, they want a period where there's a zero balance on the line of credit. So you paid it all off. The reason they want you to rest the line once a year is that demonstrates, hey, look, we've got so much success and so much flow that we don't actually need the line of credit. Again, this goes back to kind of the silly thing. Banks want to loan money to people who don't actually need the money. Resting the line, since that happens once a year, a great way to do this is if you get a big case result, use that case result and then rest the line right away before you make any sort of distributions. Now, recognizing you can't use the client's portion, you can only use your fee portion to do that. So if you get again, let's say you have $1 million line, you get a $3 million settlement, you get that $1 million fee come in, rest the line immediately, and then you get another 12 months where you're able to use the line. Other things that can sometimes make bankers a little bit nervous is if you suddenly pull out the entirety of the line without any sort of explanation to the banker as to why you're doing it. So what I mean by that, if you have a $2 million line and for months and months and months, you're at, $100,000, $150,000, but just before the line is about to mature, you pull out two, they will get nervous. So you want to have an open communication with your banker and make sure they know what you're doing. While this is a rare circumstance, something that you don't necessarily want to have happen, sometimes you might find yourself in a very expensive case, and that case is taking longer than you thought. Jess, I'm losing track, and instead of walking, I'm just focusing on the camera. So, do you want to walk? You want to sit? Okay, I'll share with you, the audience. Jess is funny about when it's a little breezier today than usual, and so she's still getting used to the city, and the breeze throws her off a little bit. So we're doing more of a standing talk. This is the moving episode. So if you have one of these cases, and hopefully you can be proactive with your banker and say, hey, we got a 60-day trial continuance. Our burn rate on experts is going to be $200,000 instead of $100,000. And because this is a good liability case, we are confident that we're going to get the right verdict or that it's going to settle. But we need more money. It's a hard conversation to have. If you've had a long relationship with your banker, oftentimes your banker is going to say, gosh, we really don't like to hear this. Let's take a close look at the cases and everything else. But we want to make sure that you can see this through. As a side note, if your banker's unwilling to do that, your next best bet on the contingent fee running of things is to call a good fellow plaintiff's lawyer. A lot of plaintiff's lawyers are willing to make investments in cases that banks won't. So if you call up somebody who has been successful, has some cash on hand, they might be willing to front you money for points on the case. And that's a way that you can kind of see yourself through a thin spot in terms of the case. There are some other tools that lawyers use to get their cases going. One is litigation financing. Litigation financing is when you have an outside entity different than a bank who will take a look at your cases. You need to oftentimes submit a fair amount of information related to the cases, and they will then be willing to do either recourse or non-recourse funding on those cases. Recourse meaning if you lose the case, you have to pay them back. Non-recourse meaning if you lose the case, you don't have to pay them back. Obviously, non-recourse is going to have a higher fee on it. Pros and cons on litigation financing. The pro is you can help spread the risk, and you can oftentimes get loans on things where a bank might be less likely to loan. The downside is that with litigation financing, you're going to end up giving more of your case result to somebody else. Different firms have different approaches on whether they consider that a case cost or not. Our view generally is that we're contingent fee lawyers, we're taking the risk on cases, and because we get the upside of the attorney's fee, that's built into the financing side of things. And so adding that finance cost onto the client's recovery seems like a little bit of a challenge. Am I going to follow you now? I think I'm supposed to be the alpha, but I can never really tell. So if you have, say, a really big case where you don't want to have to worry about co-counseling and you're not going to be able to afford the case costs otherwise, that might be a case where you consider litigation funding. And we touched on co-counseling briefly, but co-counseling is also a wonderful way to be able to spread risk on cases. So a final piece on litigation financing, and actually any sort of situation where you are potentially going to run into economic issues. A lot of those solutions don't happen overnight. Litigation financing usually takes a while to be able to get them to the information they need to be able to make a decision on a case. Same is true with plaintiffs' lawyers. So if that's something that you're going to feel like you're needing, always best to be thinking about that earlier on in the process. Those are the various ways that contingent fee law firms, contingent fee lawyers, fund cases. There is one that I'm not going to get into detail on because, quite honestly, it's above my pay grade. And I do know that there have been inroads in larger cases, mass torts, where private equity will get involved in bankrolling the very high costs that are necessary to keep those cases going. So when I say that it's above my pay grade, we're not a mass tort firm. If you're already in that world, this episode's probably not for you, and hopefully maybe someday I can sit down with you and learn a thing or two myself. That's the world of contingent fee funding. The next time you are sitting down with an owner of a firm or a partner, if you are not one yourself, recognize that a lot of this takes, there's a lot of stress involved, a lot of risk involved. It's not for the faint of heart. And if you do it well, it can be very financially rewarding as well as emotionally rewarding in terms of the results that one is able to get for one's client. So, hope you enjoyed the episode. If you did, please give us a 5-star review on your podcast platform of choice. Share us with a friend. If there are things that you want us to address on the show, please let us know at podcast@coopers.law. And for all of you doing justice out there, happy hunting.